Hi, and welcome to another edition of Danny Brown Talks Phoenix. I am your host, Danny Brown, and today I'm joined by Jon Schwab, who is a bankruptcy attorney here in Phoenix, and he's also kicking my butt in fantasy football. Welcome to the show, Jon. I appreciate you coming in.
Yeah, thanks for having me.
Yeah, so why don't you tell us a little bit about yourself, how long you've been doing bankruptcy, and a little bit about bankruptcy as well.
Sure. I got licensed in spring of 2015 and got into bankruptcy shortly thereafter. Just right when I was freshly licensed, I was doing part-time jobs for several different attorneys. So the idea is what they have. If you're a successful attorney, you have court hearings all over town, and you have to be 5 places at once. So they find a rookie like me, and they say, "Here's $100 for 5 minutes of your time." So right when I first got licensed, I was doing a lot of criminal matters, some family law stuff, and then bankruptcy was the most consistent work. That's where I developed all my experience, and that's where I got picked up with a full-time job I got. Just over 2.5 years ago with Wright Law Offices. So,
Okay.
Did you want me to talk about bankruptcy? Or?
Yeah. So why don't you start by telling us what bankruptcy is? I mean, I think everybody has a general idea, but coming from you, what is bankruptcy? What's kind of the definition?
Well, it's where you can't keep up with your expenses, and so when you start to get those phone calls that are harassing you for payments, or you're behind on your car, behind on your house, you come to a place like us and you call a bankruptcy attorney to see what your options are. Now, the two main options for filing personal bankruptcies are Chapter 7 and Chapter 13. Chapter 7 is basically saying, stick a fork in me, I'm done, I can't pay anyone back, and you're only allowed to keep a certain amount of property. So Arizona allows you to exempt certain different amounts. You're allowed to have, for example, a vehicle with a certain amount of equity, a house, household goods. You can only have $300 in your bank account. So there's a lot of things we look for to see if you're a good fit for Chapter 7. If you have property above and beyond that, you may want to consider Chapter 13. So Chapter 13 is where you keep all your property, but you got to pay your creditors back based on your income. So you have to have enough money to pay for everything that you're keeping.
So it sounds like Chapter 13 is kind of a restructure.
Exactly.
I think we hear that term a lot, restructuring your debt, where Chapter 7, does it just get rid of everything and takes you back to zero?
Exactly. You're wiping everything right. Well, it doesn't necessarily mean you go back to zero. You're allowed to have up to $150,000 equity in a house. So it might mean that you're putting money into your house before filing. It might mean you're paying back certain debts that would benefit you, like student loans that aren't dischargeable, or putting money into exempt property prior to filing. Now, you got to be careful about doing that because it can't be a bad faith deal where you're trying to get rid of a bunch of money right before filing. But just because you file bankruptcy doesn't mean you can't come out with assets at the end of it. You need to essentially plan and talk with an attorney before filing.
When would you advise someone speak to a bankruptcy attorney? When they're first getting into problems paying back their debts?
Well, the best time to file is when your income's the lowest and you have the least amount of property. If you know something's coming to a point where you're going to have to file, like say your work's closing down, or there's a life event that's about to happen where you're not going to have a source of income, it's best to talk with an attorney as soon as that event happens. Or if you just balance your budget and you realize that everything doesn't add up and you have to start picking things to cut out. If it gets to that point, what happens is if there's not everyone you can pay back, they ramp up collection activity and you can be sued. And if a creditor gets a judgment against you, they can garnish 25% of your wages until you either pay them off or file a bankruptcy.
Is that really common if you've just got mounting credit card debt and you just let it go to collections? Is it common for them to put judgments against you and take your wages for credit card debt?
Well, they call it the $181 risk because it's $181 to file a lawsuit against you. So it just depends. If they look at your credit score and it's pretty high, then you're a safer risk to go after. It just depends what your income is, how much property you have, but people do it. I mean, they get judgments against you. different companies are faster at going after you than others.
Sure.
But yeah, if you're not current on your credit cards, there's a real good chance that you'll get sued.
Wow. I had no idea that they did that. I just figured your credit got destroyed, you got sent to collections, and it kind of just eventually disappeared.
No, no, they'll sue you. They'll get their attorney's fees, and then if you're working, they find your employer. They'll garnish.
It's usually a collection agency that they're buying your debt for pennies
they'll
on the
hire a
dollar.
law firm.
Yeah.
Sorry to talk over you, but
No.
they'll hire a law firm who will then sue you, and then you either fight that lawsuit and lose, assuming they have evidence and you had a credit card and used it, which you'll probably lose.
Sure.
And then once they get that judgment. I mean, you can try to settle with them, but the problem is once they get that garnishment set up and they're taking 25% of your income, there's not much power to negotiate a settlement with them. So it's a lot easier to settle before they get that judgment. It's easy to settle if they don't have property they can take from you, but once they get that garnishment set up, bankruptcy is usually the best option.
What I've learned in general about most attorneys in situations where you need an attorney, it's best to talk to the attorney before you need them. Would you kind of agree with that when it comes to bankruptcy?
Yeah.
Because then you can kind of plan the next steps rather than just having the shit hit the fan.
Yeah. I mean, it's always a better idea. The sooner we can talk with you, the better you can plan out your options. To be honest, people in general hate seeing attorneys, and so we're usually the last option.
You guys are really expensive.
Well, and every day when people come to our office, they always say, "I never thought I'd be here with a bankruptcy attorney," and it's everyone from very successful people used to making over $1 million a year to people that have no source of income and are basically homeless. But,
Sure.
Most of the time, they don't contact us until it's the last option, to where either they're already being sued, they're already having property taken from them, and they really don't have any option other than filing bankruptcy to stop the collection activity. The smarter people that, it's the sooner you can talk to us, the more options you have. So if you can bounce out the budget and see it's not working, the sooner you get into us, the better.
So is there a time where you wouldn't advise someone to file bankruptcy?
Yeah, all the time.
What are some examples of someone that you would say you are not a good candidate for bankruptcy? You should work through your debt issues.
Well, if you've got property you lose through bankruptcy.
How do you lose property through bankruptcy?
Well, let's say you have a second house that you're renting out. That is technically business income. That's not your personal house that you're living in. And so I can't protect that through Chapter 7 bankruptcy. So let's say that house is worth $500,000.
But if you're smart and you put that in a LLC,
then it's definitely not protected.
It's not protected?
No. Well, so the business can stay alive. But what happens is if you're the 100% owner of that business and you file Chapter 7 bankruptcy, the bankruptcy trustee can take all of your ownership in that business.
Wow.
So that'd be
really
a bad idea. Yeah.
Yeah. But Chapter 11, you could potentially file.
Well, so Chapter 11 is different than Chapter 13. So Chapter 11...
Chapter 13, sorry.
Chapter 13 is usually the next best option.
Yeah.
So Chapter 13, you keep all your property. But if you had a non-exempt asset of $500,000, you have to at least pay your creditors the same amount they'd get through Chapter 7. So
when you say, talk to me like I'm 5. When you say a non-exempt asset of $500,000, so does that mean that the value of the property is $500,000 or that you owe over $500,000 on it?
So your second property, the one I can't protect, if that's worth $500,000, you would lose that in Chapter 7. In Chapter 7 or in Chapter 13, you get to keep that property, but you have to pay at least what you would have through Chapter 7. So Chapter 13 is a plan where you pay your creditors back over 5 years, and your unsecured creditors have to at least get $500,000. So that's in addition to everything else you're paying off and keeping in Chapter 13. And sorry, there's a couple layers. It gets more complicated, but basically you have to add $500,000 to your bill in Chapter 13 if you have a non-exempt property of that much.
Okay. That kind of makes sense.
Sorry, it becomes more complicated when you're restructuring, but essentially if you've got an asset that valuable, at that point it makes more sense to sell it and try to settle with your creditors at 40 to 50%. It would be a good result versus filing bankruptcy. And depending on how high your debt is, but in that circumstance, you might be able to settle for less than what a Chapter 13 restructure would get you.
Okay. And that's where talking to a really good bankruptcy attorney is probably going to help structure and advise someone. So if someone came to you and owned rental properties, your advice to them would be to potentially sell those, cash out before we start the bankruptcy process?
Potentially. I mean, the problem is it's really hard to get rid of that much money. I mean, there's still good options in bankruptcy, because if you go the Chapter 13 route, let's say your credit card debt's only $50,000. Filing Chapter 13 immediately stops all interest that's accruing on it, and you can stretch that debt out over 5 years. And so in Chapter 13, you have to pay off all your secured debt besides mortgages, and you don't have to pay back student loans during a bankruptcy. But all other unsecured debts, so like credit cards, medical debt, any other debt you've accrued, you can stretch that over 5 years. And that's 60 months. And if you're paying back $50,000, then you're making a payment of, that's probably in the ballpark of $800 a month. Versus outside of bankruptcy, where you're paying everyone back individually and they can accrue interest.
Right. And those minimum payments tend to add up, and especially on credit cards, your minimum payment, it can take you 20 plus years before that debt is paid off.
Yeah, it can snowball. I mean, that's why Chapter 13, you have to come out debt free, other than paying off your house and student loans. So it can be a good result for you, even if you have property that essentially non-exempt property. If you have a couple rental houses, if you have a second vehicle, a boat or other property that you couldn't necessarily protect in Chapter 7. In Chapter 13, you're not saving a whole lot of money, but it's reducing everything to one payment, and you're coming out debt-free.
And it's freezing interest payments.
And it's on unsecured debt, it freezes it.
Which is huge, because, I mean, credit card interest, again, it
could be over 20%.
20%,
yeah. And then secured debt, so if you're paying off a car, we can reduce the interest rate you're paying to prime rate plus 2%. So some people finance cars at 20-25%, and then we cram it down through Chapter 13 to, I'm not sure exactly where prime rate plus 2 is at, but somewhere around 6 to 7%. Right. So you can actually save quite a bit of money going that route as well.
Okay.
So there's actually a lot of people come to us to file Chapter 13 because they want to come out with a paid off car and other debt, and their bankruptcy payment includes their car payment and is less than what their current car payment's at.
Jeez.
So sometimes by stretching things out and cramming down the rates and cramming down the value of what we're paying, we can save quite a bit of money.
Wow, that's really interesting. So, I don't think anyone ever goes into anything planning on filing bankruptcy, right? And so, at least you hope not. So are there things that people can do or put in place now? Obviously I'm in real estate, so a lot of our audience listens for real estate advice and that kind of thing. So in terms of your personal assets and things you own, are there things that you can do now? So if I'm buying an investment property, for example, is there something that I can do now to where if, say I hurt myself or I get sick and all of a sudden I have tons of medical bills and I have to file bankruptcy in the future? Is there something I can do now to protect that property to avoid it becoming part of the bankruptcy process? Like putting a partner on there, so say your spouse, or putting it in a trust, or anything that would keep it protected and separate from a personal bankruptcy?
Well, as far as protecting the house, there's nothing I'm aware of that you could put it in a trust or another business, or Arizona's a community property state, so your debts are shared just like your property's shared. So there's nothing I'm aware of that you could set up now just in case, if bankruptcy's the nuclear option for you, and, you never know. You could get sick, you could lose your job, you could... most people never plan on it.
Right.
Really, the best thing to do is make sure you have a retirement account set up that you put in regular contributions. Those are going to be 100% protected. So you could come out of bankruptcy with $500,000 in a retirement account.
So your retirement accounts are protected
Yeah.
in bankruptcy proceedings. So a judge couldn't put judgments against.
As long as it's just a regular contribution every month to it, you can't just put 20 grand in there the day before a case is filed. But
Sure.
I mean, people have tried everything, but that would be, I think, the best option. I mean, owning real estate is a great investment, and there's a lot bankruptcy can do to protect properties. And usually what bankruptcy does, if you're going downhill and there's, that second property you can't protect, bankruptcy often buys you time to sell it, get the equity out of it before a bank can foreclose on it. But ultimately keeping everything and not paying for it isn't an option.
Okay. So that's really good to know. So I know back when the recession was hitting and a lot of people were doing short sales and trying to do bankruptcies at the same time, when I was processing short sales, you weren't able to do a short sale while you were also going through a bankruptcy. Is that still the case? Not that there's many short sales going on anymore, but...
Well, I don't know for sure on the short sale side. I mean, I've never seen that prevent a sale. I mean, basically what happens is if you're in the middle of a bankruptcy, we've never had an issue getting a house sold. We just have to make sure that the bankruptcy court first has to prove that it's value being exchanged for value. So you can't just gift it to a family member. But as long as it's sold at market price, I've never seen anyone object to it.
Okay.
So I've never seen a short sale prevent it.
Okay, good to know. So you've used the term exempt and non-exempt a couple times. Could you kind of give me some examples on what that means? What's the difference between non-exempt and exempt assets?
Yeah, no problem. So exempt is what you're allowed to keep and come out of bankruptcy successful. So the whole purpose of bankruptcy is to get a fresh restart, come out and go, have a successful life afterwards. So the point isn't just to leave you in the mud and never get back on your feet. So what you're allowed to come out of bankruptcy with is a vehicle. And this pertains to Arizona. If you haven't lived in Arizona for the last 2 years, there's other states exemptions that may be used. But particularly for Arizona, you're allowed to have one car that has up to $6,000 equity in it. You're allowed a house with up to $150,000 equity. The bank account's $300, so you got to be really careful on the day you submit your case. Can't be right after you get paid. Let's see, what are other major things we look at?
And these would all be things that are exempt. That
you're allowed to keep. You can prepay your bills a month out. So, if we file a case December 2nd, you can prepay your January bills. So that way you have some breathing room, because the frustrating part for a lot of our clients is when they come in, they might have $3 or $4 grand in their bank account, and it really hurts them to tell them you got to spend everything down right before your case gets filed, because they're already under immense stress coming to us. But that's one thing they can spend the money on to their benefit. So you pay your next month rent or mortgage, you prepay next month's car payment, utilities, cell phone, cable, stuff like that.
Yeah. And you advise people on how to kind of strategically do that?
Yeah. Oh, definitely. Yeah. I mean, you can buy up to 6 months worth of food. So that's a huge one where you can make a couple big Costco runs or Walmarts.
Oh, that's nice.
Just to get yourself set up.
Yeah.
So
can you buy gift cards?
No, definitely not.
Well, if you go to the grocery store and you buy like a Fry's or Costco gift card, would that not?
That would be an asset that's non-exempt. So you'd either have to turn it over, or like you'll say it's for $100, or
so they actually do they look at then the food receipts to make sure that you actually bought food?
It varies by trustee. So
they're not very trusting.
Well, it just depends. I mean,
being called a trustee.
Yeah. So it just, I mean, for them to get involved, they usually don't look at purchases under $500, just because they can't take property from you unless they do it for the benefit of your state. So they're not gonna, look through everything with that closely unless they can gather at least $1,000 or more dollars from you. So if you have $500 in your bank account on the day the case is filed, I can only protect $300, leaves $200 non-exempt. They're not just going to take $200 just because they can, because once they take property, they have to notice all your creditors there's an estate, and they have to divvy it out amongst them and their priorities. So usually, once they create an estate, they're going to take every penny they can, but they usually need to make at least $1,000 before it's worth their time to go after you.
Okay. So from the day somebody files bankruptcy, how long does it typically take for someone to be able to get back on their feet and basically be normal again? So I guess let's I'll rephrase that and start over. So you file bankruptcy and you file the Chapter 13, and you've restructured your debt. Does that kill your credit?
No.
No.
So usually it varies case by case, but most of the time by the time you file bankruptcy, you've stopped paying back everyone you're going to discharge through bankruptcy. So so your credit's probably in the
shot
garbage
already.
Yeah, and so what happens is you instantly become a safe bet to your creditors because you can't file Chapter 7 again for another 8 years. And so your credit, what happens? Your credit score, all your debts get changed to 0, and they have to stop reporting anything negative against you. So your credit usually jumps up to about 650 is a general rule. If you're above 650, you're probably going to take a hit. Chapter 13, where you're restructuring, all your secured property, like your mortgage, if you have any arrearages, those instantly become current and you have to pay them off through the restructure. Car payments, if you're behind, they immediately get current. If you just had a car repoed, you can get it back as long as you file Chapter 13 within 10 days of it being picked up. The big thing is a house. If you're about to have your house foreclosed on and you have $100,000 equity in it, if it gets foreclosed on, it's just going to go for the, whatever the balance is on the payoff. So, we file a lot of Chapter 13 bankruptcies to get it out of foreclosure. They turn around and sell the house 2 months later and then get all the equity out of it. And then it's up to them whether they want to stay with the restructure or let the bankruptcy go.
Okay. And then, so we've done the bankruptcy. We've kind of worked through that process. We've restructured our debt and we're through it. How long before you're back to kind of normal?
Well, it stays on your credit as an event. So it's similar to like an eviction or a repo. So it's an event on your credit. If it's Chapter 7, it's 10 years. If it's Chapter 13, it's 8 years. Things go back to normal pretty fast. No one's allowed to collect from you at all the second your case is filed. So
that stops creditors from calling you
immediately.
Wow.
So we file a case at 5 o'clock. You get a phone call 5:01. They're already in violation. Now, it'd be a good faith mistake because they weren't aware of it. But
Sure.
if you pick up and say, hey, I filed bankruptcy, don't call me, and they call again 5 minutes later, it's a $1,000 violation.
Wow.
So sometimes people get called 3 or 4 times. We send out demand letters asking for $3,000 or $4,000, and if they don't pay it, then we get $300 an hour to go after them. So we've actually had quite a few clients get paid more than they actually paid us to do their bankruptcy.
Wow.
So,
through those violations?
Yeah.
So could you theoretically take the money from the fines and then just apply it towards your debts?
If you wanted to.
Yeah.
Yeah, you can do whatever you want with it.
That's funny.
Yeah, the law is really harsh against people who try to collect from you while you're in bankruptcy.
Mm-hmm.
So it just endangers the entire case. And we don't really it depends on who does it. If it's a collection company going after you, we're probably going to hammer you. But if it's a mom and pop shop or someone that just doesn't understand the bankruptcy code, we're usually pretty forgiving. And,
Sure.
we'll give you a couple phone calls and tell you to quit it before we hammer you. But at the same time, if someone's making a mockery of the bankruptcy code and they keep collecting against you, it's wasting our time. And at some point, we got to get paid for it.
Yeah,
So,
absolutely. Speaking of payment, so obviously someone comes in and they're filing bankruptcy. They probably don't have a lot of money.
Yeah.
So who's paying you guys?
Well, it's that's the toughest part. So if they can stop paying back certain creditors and pay us, that's usually the best way. So if they're keeping up on their credit card payments, we tell them to stop using their credit card, stop paying them immediately, and that usually frees up some money to pay us. You always want to stay current on your house and car if you can. If that doesn't, if you've already got to the point where you can't pay that back, it becomes really tough. You can receive gifts from friends or family to pay for it.
Can you file bankruptcy against your bankruptcy attorney?
You can, yeah. Let's say someone hired me and then fired me a week later and they still had a balance, then if they went and did it afterwards, yeah, they could include me. Huh. It's usually including like your divorce attorney that you owe a fat balance to, Which,
a lot of it's medical bills.
yeah. Oh, yeah, big
A
time.
lot of people
Yeah.
have tons and tons of medical debt.
Well, it's hard to budget $100,000 surgery,
Right.
You know, it's
hard to plan for
unexpected.
it, yeah.
You know, divorce, you don't plan for that. That's crazy expensive. Most of the cases we see, something happens, it's out of their control and they didn't plan for. It's usually not just reckless behavior. So,
Yeah.
but I mean, that's what the bankruptcy code's for, is to get you back on your feet.
What about the mounting student loan debt that's out there? If you file bankruptcy, are you protected from student loans?
So while your case is ongoing, they're not allowed to collect from you. So Chapter 7, you get 4 to 6 months of relief. And then Chapter 13, you get up to 5 years. So I've had a couple clients recently that did Chapter 13 just for that purpose, just to basically cram all their payments into one little monthly payment and then put off their student loans for 5 years and hope things are more generous down the road. But generally, student loans are dischargeable. And when I say general, I mean there'd have to be fraud by the school. There'd have to be so many circumstances just out of the norm in order to discharge student loans.
So odds are you're going to be paying your student loans back regardless of whether or not you file bankruptcy.
Yeah.
So if you're filing bankruptcy, though, and you do have student loans, is it stopping that interest and freezing it for the 5 years?
No,
So
that
it's
still
accruing.
accrues. It's just gives you some relief in the sense that they can't ask you to make the payment, but
And
it's
it doesn't
still there.
It doesn't
Yeah.
shorten it to that 5 year period that you're talking about where you can pay it off in 5 years.
No. So they get some money, so they get the same percentage that the rest of your unsecured creditors get. So in most cases they get nothing. It's just
delaying it.
yeah, most of the time it's just put it off.
So your lesson is no matter what you do, you're paying back your student loans.
Basically.
Yeah.
I've
Wow.
never had a case where we could discharge them.
So do you personally represent people when you have to go to court? And when do people end up going to court?
Yeah, I do 99% of all my firm's hearings. So you always have what's called a meeting of creditors, where 5 to 6 weeks after your case is filed, you go meet with the bankruptcy trustee. They ask you about 10 questions. They're all yes/no questions, and it's basically a formality, and then they kick you out. Your creditors have the right to be there, and sometimes they show up. It's rare because they can still file objections and do whatever they want to do, but sometimes they'll show up if they want to ask you questions on the spot. So that's
like a representative
rare.
from Visa showing up to your court.
Oh,
proceeding?
they would never show up. They just
No,
file
I
an
know.
objection.
Yeah.
But like, let's say your business reported income of $500,000 a year, and then all of a sudden, you know, you got, let's say you're showing that much income, you just got a loan for $80,000, and then 3 months later you're filing bankruptcy and $80,000 disappeared. Someone might show up to ask you where that money got spent. So
like a representative from the bank that.
yeah, they could show up and say, hey, we just got a financing statement from you saying you're making all this income and you had all these assets. Your bankruptcy filing says you don't have anything. So what happened? And that happens rarely, but I mean, not too often.
So then what advice then do you have, kind of close things out and kind of wrap up, but what advice do you have for people who, may not be in a position right now to file bankruptcy, but odds are something's going to happen in the future? What's some advice that you have for people to kind of just be prepared if you do get in that situation?
Well, I recommend prioritizing what you're going to pay. If you know everything's not going to add up, I'd first pay for the house, then the car, and then life necessities like food and clothing. Talk to an attorney sooner rather than later while you still have options. Once your creditors start suing you, you get put on a time frame to respond, and you run out of options quickly. So definitely, if you know something might be happening in the next 6 months to a year, make sure you're not paying back any friends or family. Make sure you talk to an attorney before you sell property. I've seen people try to sell the lake cabin to a family member, or just try to sell their second truck to someone kind of quick and dirty right before filing bankruptcy, and that always comes back to bite them.
Sure. The courts and these people, they're not dumb. They know.
No, they're good at their
they
job.
know all the tricks.
Yeah. Trustees, they get a percentage of everything they recover. So if they see a transfer that was made out of the ordinary course of business, they can negate that transfer, and so they can go take back vehicles, houses. And they get 10% of everything they recover. So they'll go after you.
This is a really stupid what if question, but it just popped in my head. So, could you do a strategic divorce and then file bankruptcy? So for example, could my wife divorce me and take me to the cleaners and take all of my stuff, and then I file divorce or file bankruptcy after that, and then we're not married anymore. She has all my stuff. And then once the bankruptcy's over, in 5 years we could get remarried and I get all my shit back. Could you do that?
Well, no. Well, there
No?
are some tricky things you can do, and it's through Chapter 13 bankruptcy. But essentially, since Arizona's community property state, even if the family court orders one spouse to pay all the debt, your creditors don't care. They can still go back after both of you. So if the spouse who's supposed to be paying doesn't, then they just go after the other person. The tricky thing that I think is kind of interesting is in Chapter 13, after you file, if after a divorce, you have to pay back child support and maintenance. You have to stay current on that. But if there's just a property division where one spouse is ordered to pay the other spouse $50,000, and then they go file Chapter 13 bankruptcy, the property settlement, that obligation to pay back that spouse can be discharged through Chapter 13 bankruptcy.
Wow.
You only have to pay back your excess income. So it doesn't come up very often, but if you go out through a divorce and you get some of the property in your order to pay the spouse, it's possible that you can discharge that obligation to her or him.
Interesting. That's kind of a way to stick it to him, I guess, in the end.
Yeah. It's not too it's just one thing we look at. It's usually not. It's not very often that people walk into a bankruptcy office when they're splitting up property. It's usually
After
when it's
the
splitting
fact.
up debt. But it's one of the tools we can use.
Yeah. Well, it sounds like basically from what you're telling me is if you are in financial hardship, that you have options, and that people, if they're in that situation or that situation's looming, that it's better to reach out to somebody sooner rather than later.
Yeah, absolutely. I'd say the biggest thing, especially with houses, because this is a real estate deal, is if you're facing foreclosure, talk with a bankruptcy attorney about Chapter 13, just because it doesn't make any sense to let the bank foreclose on your house when you can put it up for sale, get all the equity out of it, pay back the bank, they're still getting everything they're owed, and then you get something to show for all your house payments you made.
Yeah. So on that though, so you sell your house, you get the equity. Do you get to keep those funds, or will those funds from your equity then be garnished?
No.
So that's protected.
Yeah.
Okay. That's great to know.
Yeah.
Good.
The only reason why they'd be garnished if someone else went after you afterwards.
Okay.
But no, that's yours to do whatever you want with.
Cool. Well, if anybody has any questions for you after this, what's the best way for them to get a hold of you?
Well, you can give me a call. I don't have my number memorized off the top of my head, but number is 602-456-4699. Or you can email me. It's my name, J Schwab, it's JSCHWAB, at azbklawyer.com.
Okay. And we'll make sure we put that in the show notes as well. So if anybody wants to reach out to you, they absolutely can.
Okay, cool.
All right. Well, thanks so much for being here. I really appreciate it. This was another edition of Danny Brown Talks Phoenix, and thanks for tuning in.